have to tell me they're a cop if I ask, right?
I can't go to jail for not paying a debt, can I?
The courts in this state favor women. Men have no rights in a divorce, do they?
I've heard if the police don't read you your rights, you can't be convicted. Fact or fiction? Listen in as we break apart the myths and get the truth with the top legal experts from around the country. Welcome to Legal Mythbusters Radio with your host, Corey Vandenberg.
Hello, this is Corey Vandenberg, the host of Legal Mythbusters Radio, and I am joined on today's show by Lewis Adams. Lewis is a bankruptcy lawyer in Salt Lake City, Utah. He has been practicing for 19 years, attended law school at the University of Utah School of Law, and Lewis has some particular areas of expertise, but what we're going to focus on today is a very persistent myth that I've heard in the industry ever since going back to my days of being a real estate agent, and that is if you are looking at doing a bankruptcy or a short sale, there are a lot of investors and people who would encourage homeowners to do short sales instead of a bankruptcy. And the logic that they use, they'll basically say, well, if you have a bankruptcy, that's pretty much like a foreclosure. Those are the two worst things you can possibly have on your credit report. You know, you're much better off doing a short sale. What do you say to this perception, Lewis?
Well, I disagree. I don't think that a short sale is that much better than a foreclosure itself. Foreclosure and the bankruptcy, the short sale all seem to have the same impact.
Okay, and why? So why do you believe that this has become so prevalent then, if they're equal?
I think it's something that the real estate industry has created, partly because the real estate agent does get a commission, and it is a way to eliminate property from foreclosure. But I just don't believe that it has a big impact.
Okay. And have you actually had clients who've gone through this process, having tried a short sale beforehand and then decided to file? And what was the outcome or the result?
Well, I'll give you an example. Someone files a bankruptcy and they want to try and purchase a home down the road a ways. It takes about 2 years for them to get a loan. Somebody who has a foreclosure and files a bankruptcy, it takes about 2, maybe 4 years down the road to get a loan. Somebody has a short sale, it takes about the same amount of time. So I don't see that there's a big difference depending on which direction they go. It seems to me like if they want to purchase property down the road a ways, it still is going to be anywhere between 2 to 4 years, regardless of which direction they go.
Okay. And so what are some things that people need to be doing in advance? Or maybe a better way to ask this question is, if they find themselves in this situation, at what stage should they be talking to a bankruptcy lawyer and weighing their options between doing a short sale or filing?
Well, I guess the difference is whether or not they want to keep the property. I mean, if they want to keep the property and they're delinquent on their payments, then a Chapter 13 is a way to protect that property. If they're really not wanting to keep the property, I don't know that it matters whether they're current or delinquent. If they're going to eliminate this property from out of their life, I think the bankruptcy will take care of it either way. Once the bankruptcy takes effect and they want to purchase a property 2 years from now, say, for example, it's really going to be based on their credit, where they've been since the bankruptcy more than anything else. If they would otherwise qualify for a loan, I don't think that it matters.
Okay, fantastic. And so somebody who has done a short sale, sometimes they can still end up with tax liabilities. Is this something you've seen happen with any clients that have come to you after having done a short sale?
Yes, because if the lender takes a loss, they do have the right to send a 1099 to that particular debtor. In fact, if they want to write that liability off on their taxes, they've got to show a corresponding benefit to somebody else. If it's a loss to them, they have to show a corresponding benefit to someone else. And so it's not unusual for someone who's been in a short sale situation to receive a 1099 that they now have to add to their tax income as if it were income. In a bankruptcy, that's not the case. In a bankruptcy, because they are insolvent, there is a provision in the tax code that says that 1099 basically is invalid, that it has no import. And therefore, if in fact they are saddled with the 1099, that bankruptcy can in fact eliminate that debt.
Are there any things that people often do in the process of either during a foreclosure or leading up to needing a bankruptcy or a short sale that they typically engage in that actually hurts their chances of seeing success or getting out of the situation that they're in?
I think one of the biggest problems that I see is that if they let it go too long, then obviously their credit is being injured. If they were to file a bankruptcy once they realize they're in trouble, their score really stays intact more than you would think. The score stays a little higher. It's a little easier for them to rebound. But the longer it takes and the longer they're in default, the score just plummets. And it's a lot harder for them to recover. It takes a little bit longer time, if in fact that's the case.
So is it really possible for somebody you mentioned wanting to keep the home. I know this is used quite a bit by investors who are looking to buy homes from people that are in distress. Is it really possible to save a house using a bankruptcy?
Absolutely. It can only be done in a Chapter 13. Since the Chapter 7 is a liquidation, it simply is going to eliminate the debt. However, in a Chapter 13, they can take that delinquency and they can pay it off over a period of up to 5 years as long as they can make their ongoing payments. So if they've had a situation where they lost a job and they got behind on their mortgage for 2 or 3 months, and it's just almost impossible for them to pick up and cure that delinquency, they can do that over time in a Chapter 13 bankruptcy. We can set up a plan of repayment that will allow them to retain the property, and it stops any kind of foreclosure action that may be taking place. Debtor then can continue to remain in the home.
And what about refinancing? That's a pretty popular way to handle a mortgage. Is there an option for somebody in a Chapter 13?
Oh, absolutely. In fact, there's a number of programs that are specifically for people in a Chapter 13 for them to refinance their home. And that can happen as early as a year after filing, even before they're finished with their plan. It's not uncommon at all, and we do it on a regular basis.
That's fantastic. Louis, this has been really, really enlightening. I really appreciate your insights on this. I hope people understand that just because you're having some difficulties with your mortgage, don't necessarily buy into the idea that a short sale is the best of all your options. In fact, I do want to add a caveat that there's maybe one exception to the rule. Have you had an experience with any one particular lender that people should be aware of, the exception to the rule?
Over the last couple of years, Bank of America simply refuses to foreclose on a property. And so sometimes a lender or a debtor has decided to let the property go. And for whatever reason, Bank of America simply won't pick up the property, whether it's in a Chapter 7 or a Chapter 13. They won't foreclose. They won't do anything, try and take that property back, and the property sits. In the meantime, that particular debtor, even if they've moved out of the home, is still responsible for the upkeep of that property. If the weeds grow too high, they may be fined by the city or the county or whoever it is that attempting to try and maintain that community. They are still responsible for HOA fees. And if those HOA fees are not paid, the bankruptcy won't discharge those ongoing fees, even though they may be surrendering the home. And so sometimes it's better, and only usually for that reason, to do some sort of a short sale just to get that particular debtor out from underneath that home, when you have a lender who simply won't do anything to foreclose or take that property back.
Fantastic. That's great to know. So if you do have a loan with Bank of America, you may be better off. However, I would say in that circumstance, or I should ask you, even if they have Bank of America, should they be talking to a bankruptcy professional just to make sure that they're planning everything correctly?
I think it would be wise. It never hurts to talk to a professional who has some experience, who has dealt with different lenders over a number of years, to get some advice, if nothing else. It doesn't obligate anyone to ever file a bankruptcy, but it certainly puts them in a position where they at least have an understanding as to what their options are, the impact of those options, whether or not it's going to affect them monetarily, and down the roadways, of course, how it's going to impact the possibility of maybe purchasing another property.
Got it. Fantastic. Louis, it's been an absolute pleasure. Thank you for your help.
Thanks for listening to Legal Mythbusters Radio. More great content coming next week. Please note, note, this show does not represent legal advice for your specific situation. You should always seek counsel for your specific case. Listening to the podcast does not constitute the forming of an attorney-client relationship.